Good morning. My name is Jean Shearer, or afternoon, depending upon the time zone that you are calling in from. Welcome. I am with the Partners Group, and we're going to go ahead and get started in the interest of everybody's time. Joining me today is Darris Freeman with Unum, who you will meet in just a couple minutes. We're happy you could join us today for our webinar on the Washington Paid Family Medical Leave Law. As you may know, the Partners Group, or TPG, hosts many webinars throughout the year. Based on the significant response we've received to this webinar, it confirms what we thought, that this is a topic of high interest. The purpose of today's webinar is to provide an update on Washington's Paid Family Medical Leave Law and provide information that will help equip you and your organization on what you need to know to be prepared for the changes that will take place beginning January 1, 2019. Before we get started, as always, there are a couple of housekeeping items to take care of. The first is that CE credits are available, both for HRCI and SHRM. Upon successful completion of this webinar, you can redeem those credits. We'll send an email out, and there will be instructions on that email on how to go about that. Also in that email will be a link to the recording of this webinar. It is being recorded today. And then finally, we hope to be able to answer questions at the end of the webinar, but in the event that we don't have time to do that, we are going to ask you to submit your questions during this presentation using the chat box, and we will roll those all up in a Q&A and provide those for all attendees. We hope to provide that email with those three things within the following week. So finally, there is one thing at the end of the webinar that we ask please to take the minute to do. There will be a short survey. It's only 4 questions, and we would really appreciate your feedback if you could take a minute to do that. So with that, we'll take a look at our agenda. Sorry. There we go. So here's an agenda of what we'll cover in the next hour. We'll start with a brief overview of the Washington Paid Family Medical Leave. And then Darris will walk us through the ESD timeline. ESD is the Employment Security Department, and they're the ones that are administering this benefit, and where they are currently at working towards this January 1, 2020 go live benefit effective date. We'll also cover some of the developments that have arisen out of the rulemaking process. We'll share an overview of the state and voluntary plans, a side-by-side comparison so you can see both options that should help you decide what might be best for your organization. And we'll cover what we have seen so far in terms of the vendor response, both for administration and potentially benefits to help employers supporting this plan. And then finally, we'll spend some time to talk about some important considerations, some potential impacts, and what you as employers may want to consider before this leave law takes effect. One caveat in bold, this information presented today is to the best of our knowledge current as of today. And I say that because many of the details have not been finalized, as you'll see when Darris talks about the rulemaking process, or have been taken back for further consideration based on public comment. So with that in mind, let's start with some brief introductions. Okay, I'll get this figured out. I've got to go the right direction. There we go. Okay, thanks for your patience. So again, I'm Jean Shearer with the Partners Group, and the area of absence management, including both integrated disability, leave of absence, those have been areas of focus for me throughout my entire career. I have the pleasure now of working with the Partners Group and with clients who really find and helping them find solutions regarding their concerns around these areas, around their leave of absence, around their ADA and their disability programs. The Washington Paid Family Medical Leave Law is just one example of the increasing complexity that I'm sure you all experience and the additional responsibility that it places on HR teams and benefit teams to administer and really figure out how these will coordinate or integrate, or if they will, with your other plans and processes that are already in place. So one reason why our total absence management team continues to grow and stay busy is because of this Washington Paid Family Medical Leave Law. Okay, so here you can see our total absence management team, or TAM, has 5 members. all of whom have a depth of experience and extensive backgrounds in the area of total absence and disability management. On this slide are some examples of the work we do for our clients. But what I can tell you is that really there are no two clients alike. Each one has their own unique set of circumstances, challenges, and opportunities. Some commonalities that we find with many of our clients is their interest in compliance and risk mitigation. Spoiler alert, nobody likes lawsuits. They tend to be expensive. Improving their overall cost of absence and gaining efficiencies, or even just starting with establishing consistency with their current policies and processes, and often multiple touch points associated to any leave of absence. For our clients, this can often result in a recommendation made to maybe outsource, for instance, to a TPA or an insurance carrier, or insource with a technology solution to help them manage their leave of absence and also ADA accommodations. We work closely with our clients. It might start by building a business case for whatever the recommended solution is, and then on an ongoing basis, managing the RFP, facilitating the decision process, implementation, and then continuing with ongoing program management. Within the partners group, sorry about that. It's a very touchy mouse. Within the partners group, you can see the employer services division on the top of this diagram. It is the largest division, both in terms of number of employees and revenue for our company. And our TAM team is part of the division, along with our data analytics and population health team, our partner well team, which includes our wellness and well-being consulting, and our employee benefits department. Our other three divisions include our commercial insurance division, our retirement planning and 401k services, and personal insurance. We are headquartered in Portland, Oregon, and started out as an individual insurance agency back in the early 1980s. Since then, we have grown to become the largest independent brokerage firm in the Northwest. We have 5 offices throughout the Northwest, 175 employees, and we are fortunate to be able to serve over 700 employers. So with that, I'd like to turn it over now to Doris Freeman for her introductions.
Thanks, Jean. Let's make sure I can advance the slides. It seems to be a challenge for both of us. There we go. So Doris Freeman, I'm Assistant Vice President and Legal Counsel at Unum. I am going into my 20th year of absence management in some form or fashion. I have worked both on the operational and business side of things as well as the compliance side. So I am employment attorney, and I support Unum's Leave Management Center, FMLA, ADA, state leave laws, and of course things like Washington Paid Family Medical Leave. Unum is we are the leading provider of group and individual disability benefits in the U.S. We have over half of the Fortune 100 companies as clients and customers. Our focus is really in disability and leave. That's where we spend our time. That's where we specialize, and that's what we're great at. We do have specialized legal resources like myself that then assist to make sure that we have compliant programs, products, services, and solutions for our clients. So I want to get into, let's go ahead and get into the Washington. That's why you guys called in. But I think we want to start first with a quick survey question so that we have an idea of who's listening today. If Keaton can launch that question for us.
All right, about
you guys
70% of you guys have voted. We'll be closing the poll here in a few seconds and displaying the results.
So it looks like we've got a great mix of employers on the phone, which we love to see. And that also helps us as Jean and I speak through these slides to know, because there are going to be different requirements for those employers that are under 50, for some that are between the 50 and 150, and then for some of the larger groups. This is very helpful. We appreciate it. With that, Jean, I think it's off to you to provide some summary information.
Thank you, Darius. Okay, this is just pretty high level, an overview of the Washington Paid Family Medical Leave Law. As you all know, this was legislation passed in July of 2017. That was after a 10-year process. The initial legislation began in 2007. So after 10 years of reiterations and some negotiations, it did come to pass in July of 2017. Washington is becoming the 5th state to provide combined paid family and medical leave. They join California, New York, New Jersey, and Rhode Island, but there are several others in the pipeline. Massachusetts has approved their leave law. It will become effective January 1, 2021, though they are beginning premium payments January 1, 2019. And there are at least other 8 states that are in the pipeline for future paid family medical leave law. So this is something that I think we'll see a continuing trend towards states, and we've already seen that same trend with cities, municipalities adopting their own laws in this area. This law for Washington replaces the Washington Family Leave, so that will be sunsetted on December 31st, 2019. And beginning January 1, 2019, employers have the responsibility to collect and remit premiums for the state plan. And in 2020, workers become eligible for benefits. Almost all employers are required to participate in the Washington Paid Family Leave Law. The few exceptions are the federal government. Tribal entities and self-employed individuals are not required to participate, but may elect to opt in. That's their choice. There are no exceptions for nonprofits or other typically tax-exempt organizations like religious or municipal organizations. So most every employer is going to be subject to this law. For companies that have represented employees that are covered by a collective bargaining unit or collective bargaining agreement, excuse me, if that agreement was in existence on or before the 19th of October 2017, they are exempt from this until that CBA expires, is opened, or renegotiated. So that's something to keep in mind. There are some special provisions for small employers, though, again, they are not exempt from the law. So even for employers with less than 50 employees, they're part of the law. They do not have to, the employer does not have to pay premium, their portion. The employees will still be required to pay their portion of the premium. The state has made some financial assistance available for small groups defined as employers with less than 150 employees. And that's the number of employees in the state of Washington. So regardless if you have 20,000 employees and you've got 10 in Washington, your head count for this law is your 10 employees in Washington. So these grants are available for a couple reasons. One would be if you needed to hire a temporary worker for an employee who's out on leave, or maybe a replacement worker. The grant for that is $3,000, up to $3,000. And a grant is also available up to $1,000 to reimburse small businesses for what they call significant additional wage costs. That might be overtime, it might be training. The important thing to keep in mind is, again, it's for employers 50 to 150 employees, and not more than 10 grants will be provided in any 1 year per employer, and only 1 per employee per year. So if you have a high utilizer who is out on multiple leaves during the year, that same year, the employer is only able to apply for 1 grant per year for that individual. There is also a caveat to this. Employers under 50 employees, they can choose to pay their portion of the premium, although they're not required to. If they do, they are eligible for these grants that companies with 50 to 150 employees would be eligible for as well. In total, the maximum amount of benefits paid for either a family or a medical leave is 12 weeks per year. There are some different scenarios where that would be different. We'll go over those in a little while. The maximum payable under exceptional circumstances is 18 weeks per year. The taxability of benefits is yet to be determined. The ESD has reached out to the IRS to ask whether or not benefits received under this law would be taxable as income to the employee, and they have not rendered their decision yet on that. And this we'll talk about a little bit more, but in most ways, job protection, like it is provided on the FMLA, is also provided on the Washington Paid Family Medical Leave. And employers may opt out of the state plan. We'll talk a lot more about what that means. The participation in the law is not optional. Employers, though, can make a decision to opt out and administer on their own and self-fund the benefits, and they call that a voluntary plan. So again, more to come on that. I'll now turn it over to Darius, who will walk you through the timeline and then go over the financials of the benefits.
Great. So as Jean said, the timeline, there's a lot going on when it comes to this program. And what this state, what Washington has decided to do is to split out their rulemaking. That's the creation of the regulations. The regulations interpret the statute or the bill that was passed. And they broke it out into 6 phases. So it started back in May 2018 and will not be finished until sometime in late 2019. And so I've laid that out here. You'll see phase 1 rulemaking that covered CBAs, voluntary plans, premium. We're currently in phase 2 and phase 3 kind of simultaneously. They overlap. So they're writing the rules and the regulations related to employer responsibilities, benefits, things like that. And so you'll see the different topics on here in the different phases. September, they started taking applications for voluntary plans, and we'll talk about that piece when we get to the voluntary plans themselves. You'll notice here April 30th, 2019 is an important date. That's the first deadline for employers submitting their first quarterly reports and premiums to the state, and we'll talk about what's going to have to go in those quarterly reports when we get to the reporting requirements. Ultimately, obviously, as you go through this, we'll eventually get to January 2020, benefits will begin, and all this fun will start. So let's talk a little bit about the financials of the plan. The premium contributions, we'll start with that. So premium contributions will be 0.4% of an employee's gross wages. That will cap out at the annual Social Security max. So this year that's $128,000. So if they make more than that, that's where the cap is, and it's 0.4% of that is the total premium that gets submitted to the state. 63% of that is coming from the employee, 37% of that is coming from you, the employer. And the way that that breaks down is they've assumed that 2/3 of the claims are going to be medical in nature. So 2/3 of the premium is to support the medical plan. And what you'll see is that you take that 2/3, 45% of it's coming from your employee, 55% of it's coming from you. The third of that 0.4% of wages is all employee funded. Again, that's the breakdown, but at the end of the day, it's 0.4% of their wages. 63% comes from them, 37% comes from you. But you can see the way they've broken that down. You as an employer can choose to pay the premiums on behalf of your employees if you want to. You do not have to. Obviously, this is expected to be an employee obligation. Employees cannot opt out of the program. Okay, as a Washington worker, they must pay the premiums and they must be part of the plan. Here's just an example. Say you have an employee that earns $2,000 a week. You can see the way it's going to be $8 of total premium and how that breaks down. So just a good example so you can see it. These are, by the way, that example you can see on the website, and I think we may have included a link to that in our resources. So more important than the premiums, I think, are how these benefits are going to be paid, because there's some really interesting, they did this in a very interesting way, and it's very different than the way states prior to Washington calculated and paid benefits. So to start with, I'm going to start with defining the average weekly wage. So I think what we're typically used to in the space of disability, right, and those worlds is that what we base a benefit on is what an employee currently earns. That's not going to be the case in Washington. The average weekly wage is going to be calculated based on what they call qualifying period. It's basically the last year, the last 4 quarters. But the state will take the highest 2 quarters of that year, all wages earned at any employer, not just you, if they've got a second job, if they worked for somebody different, it doesn't matter. So all wages, the 2 highest quarters, and then average that, divide by 26 to get an average weekly wage. So that's going to be the foundation of their benefit. So that's the beginning. Now, if their average weekly wage is less than 50% of the state average weekly wage, the state, and I've got over to the side, $1,190 right now, so half of that is $595. So if their average weekly wage is $595 or less, they're going to get 90% of that off the top. Done. Okay, that one's easy. And you can see the example of that there. If they make more than $595 a week, more than, again, or earned, I should say, it's not what they make now, right? It's what they earned last year. More than that, then the way there's kind of a 2-part calculation. They'll get 90% of their wages up to that $595 cap. Then between $595 and what their average weekly wage actually is, they get 50% of that. So I have an example here on the next page. I show the actual math. I think that's a little bit granular to talk through necessarily, but you'll get a copy of this presentation and you can use that as an example. But what you'll see here is, again, if they make $595 or less, they're getting 90%. As that increases, their percentage is less, obviously. The maximum they can earn is $1,000 a week. Minimum is $100. Where it kind of hits the threshold or that cap of $1,000 a week is if they're earning $73,000 a year. That's what will that's what will hit that $1,000 trigger. That's 71% of their earnings. So it's a good amount from a income replacement perspective for folks that make more than 73. That's just, they're going to be capped out at 1,000. So here on the next slide, I told you I do all the math for you, which I don't know that we need to get into, but you can see it laid out there that you've got the first half of the calculation, which is 90% of their average weekly wage, but it caps at $595. You then take the difference of their annual average weekly wage and the $595 and take 50% of that. You add them together. A couple of additional provisions related to benefits. They have not finalized any rules or regulations regarding supplementation of paid family medical leave. It's a big question, right? So can employees take PTO or sick leave or vacation leave? There's in the statute that they can take it instead of, but there's nothing been issued yet as far as can they supplement a portion of. So lots of questions have been asked in that area on different webinars with the state. The answer continues to be that will be addressed in the rulemaking process. Employees are not entitled to any PFML benefits if they are receiving either unemployment or workers' comp. So I'm going to turn it back to Jean to talk about some of the other requirements like eligibility.
Thank you, Darius. So let's talk about what workers are eligible for this benefit. The first requirement is that they're working in Washington. The next is that they're meeting the minimum hours of work in the qualifying period. And then last, that they are experiencing a qualifying event. So let's talk about the hours requirement. The 820 hours is, again, as Darius referenced, the 4 of the last 5 completed calendar quarters is what's considered the time period. And if they've met the 820 hours in that time period, they have met the hours requirement. That averages out to be roughly 16 hours per week. And it is cumulative. So regardless of the number of jobs or the number of employers your employee has had during the year, those all count. It's cumulative towards establishing that 820 hours. This is because the eligibility for the state plan is portable. you do not have to reestablish eligibility with your new employer. So you could potentially have an employee who shows up on the first day of work or takes a leave in that first week of work. If they've already established their 820 hours of eligibility, they're eligible for that leave under your employment. And then a qualifying event, we will talk about that here. So very similar in most respects in terms of the reasons for leave being eligible as the FMLA. Qualifying events include leave that you are taking for your own serious health condition, like you might be going treatment for cancer, recovering from surgery, have an injury. The definition for a serious health condition is the same as FMLA. The time period, and we'll talk about this a little bit later, for leave can be extended if it's pregnancy related. Bonding or placement, adoption or foster child under the age of 18 is covered if leave is taken within 1 year of that birth or placement. And then also for a family member's serious health condition, that's another qualifying event. Note that the eligibility, though, for this is more expanded than what is allowed for under the family medical leave. So all of those family members listed there in that box, parent, parent-in-law, spouse, or domestic partner, child of any age, grandchild, and grandparent and sibling. Those are all additional family members that are considered an eligible family member for purposes of a leave taken for their serious health condition that you are caring for them. And then finally, military-related events, pre- and post-deployment activities that could include related to childcare issues because of a family member's military deployment. Those are covered as well. So key provisions for entitlement here. It's broken out 12 weeks for medical leave for your own serious health condition, or you could have 12 weeks for a family leave. Those would be the bonding, care for another family member's serious health condition, or the military reasons. If you have both of those in the same year, for instance, you might be a new mom, so you have 6 weeks of medical leave, and then you decide you want to take bonding leave right after that. So you would have another 10 weeks available to you for that family leave for a combined total of 16 weeks. So if you have both a family and a medical leave occurring in the same 52-week period, you have a total of 16 weeks available to you. If in addition you had complications due to your pregnancy, that gives you an additional 2 weeks. So in total, if that were your scenario, you'd have a total of 18 weeks that you are eligible for in terms of paid leave for that 52-week period. Some key provisions regarding that employment, and we get a lot of questions on if specific situations are covered, if their employees working in the state or maybe outside of the state but doing work in the state are covered. The information here is taken right from the regs. I won't take time to weed through that. You can see it's pretty detailed in terms of its specificity. But basically, if you have employees in other states, only the employees in Washington are included in this program. Employees who do all of their work in another state are not included. And then I think the one that we get asked most often about is, what about workers who do their work in Washington, but they are remote workers, so their base of operations or the direction of their work is not in this state. Those are we understand, and Darius, correct me if you think I'm wrong here, but our understanding of this is that those employees are covered for the Washington Paid Family Medical Leave Law. And as a rule of thumb, the rules are the same as those employees you are paying unemployment insurance for now. So generally, any employees you are paying unemployment insurance tax on are the same employees that will be eligible for the Washington Paid Family Leave Law. Some other provisions, just as a reminder, it is said that unless expressly permitted by the employer, that the Washington Family Medical Leave must be taken concurrently with any leave taken under FMLA. So those would run concurrent. assuming, of course, that they are both applicable. The minimum duration of leave under the PFML is 8 hours. There is a 7-day waiting period for benefits, except if it's due to birth or placement of a child. And in that case, there is no waiting period. Benefits are, you're eligible immediately on day one. Like the FML, employees should be giving at least 30 days notice if foreseeable or as soon as practical. And there is certification forms that will be required. The ESD is currently in the process of creating those. We have not seen those as of yet. So as I mentioned earlier, employers
I'm gonna, yep.
Go ahead.
I was going to jump in here, Jean, and talk just before we get into voluntary plans. I wanted to talk briefly about everything we've talked about so far. I've seen some questions come through in the chat, right? Everything we've talked about so far are the rules of this state plan. And the assumption is that and we'll talk about reporting requirements when we talk about the employer requirements here at the end, but you as employers are going to be feeding data to the state, and they're going to be the arbiters of who's eligible and how much their benefits are. So they'll determine, has this 820 hours been met based on all the data they've received from all employers. They're going to determine what's the average weekly wage, and therefore what's the benefit amount based on all of those wages that were received during the qualifying period. They're going to make those decisions. And if you're going with the state plan, I want to talk about that before we get to voluntary plans, then the state will also, employees will file with the state, and the state will issue the benefit check. Okay, so that it would all go back and forth between the employee and the state. The state is allowing, as Jean mentioned, for employers to have voluntary plans or private plans. The term voluntary can be a little confusing in the insurance world, but private plans where, as an employer, you can choose to put a plan in place that either you self-administer or you have a third party administer for you that would replace the state plan. It does have to be at least equal to or more generous than the state plan. I'm on the wrong slide. There we go. It does have to meet or exceed the provisions of the state plan. It can be for just medical, just family, or both. So for instance, you could take an existing short-term disability plan, potentially, depending on how that plan's written. And when I talk about the vendor response, we're going to talk about how we're looking at some of those plans today to basically take care of the medical requirements under the state plan. And that could become maybe your voluntary plan. You could still have employees file through the state for the family benefit, or you could create a family plan equivalent as well and have voluntary or private plans for all of it. That's up to you as an employer. What we're going to try to cover here is what the requirements are for voluntary plans, how they're different than the state plan, so that hopefully you've got as much information as we're able to give you. Again, a lot of things still outstanding, but in order to make an informed decision. So as I said, the plan provisions have to meet or exceed the state plans. You cannot charge the employee any more than they would pay under the state plan from a premium contribution perspective. And of course, their contributions have to be held in trust. Once a plan is approved, or plans are effective the first of the quarter following approval. So if you were to submit a plan now and it got approved, it would be effective 1/1/19. Although there's no benefits payable yet, what that does is free you up from submitting the premiums to the state. So they're approved on the first of the following quarter. Once they're approved for a minimum of 1 year, and then they will have to be approved annually for the first 3 years of the plan. I think that's for the state to kind of keep an eye on these and make sure they're accomplishing what they intended. After that, they can be, they won't have to have an annual application and renewal. Employers, the state has said that although the state is going to be the owners of the data, employers will have access to that information if they have a voluntary plan. So you're going to have access to see, have they met their 820 hours? What is their weekly benefit amount based on average weekly wage? And what is their typical work week? So what are the hours that they're being paid for with that benefit? Keep in mind, like average weekly wage, hours are cumulative. So if they work for you 20 hours a week and they worked for somebody else 20 hours a week last year, their benefit is going to be, if they're out on leave, they get 40 hours a week of benefit because it's a cumulative amount. So it's all employment. Again, it's similar to unemployment, where they're looking at the broader picture of what that employee worked last year as opposed to what they're currently working today for you. If you do have a voluntary or private plan, there will be additional reporting requirements, as the weekly benefit and durations of any payments must be sent to the state. And that's because, we'll talk about it here in a minute, employees can collect under the state while they wait to become eligible under your plan. So let's do a little comparison on state versus voluntary plans here. You heard Jean talk about the eligibility for the state plan being 820 hours in that qualifying period. So in that 4-quarter period, 820 hours. Under a voluntary plan, they do have to meet that 820 hours, but they also then have to meet 340 hours working for you, the employer, specifically in the last 12 months. You have to then notify the state once that 340 hours is met. So when you have a new hire come in, between their time of new hire status and when they meet that 340 hours, they can still file for benefits directly through the state because they meet the 820, if they meet the 820. So then you have to tell the state, hey, they've met their 340, so they're now eligible under my plan, my voluntary or private plan. That way the state knows not to pay a benefit out of the state plan. So a lot of back and forth there, and I know that can be a little confusing, but it is something to be aware of because it's one of those dynamics of a private plan that employers need to know about. There is one exception to that 340 hours if an employee is moving from a voluntary plan to a voluntary plan. So employer A that they worked for had a voluntary plan, employer B that they moved to has one, they're immediately eligible day one. The question to the state has been, how do I know, right? So how do I know this employee that I just hired came from a voluntary plan, is eligible for benefit? Still to be determined. Okay, that's a question they haven't been able to answer yet. From a job protection perspective, and I think this is really important because we've been talking about benefits, but just because an employee is receiving a benefit doesn't mean it's job protected time. So there's you have to separate those two things in your mind. If it's a state plan, if the employee is filing directly with the state and you're letting the state handle that, they get job protection for benefits paid once they have met 12 months tenure, 1,250 hours worked, and there are at least 50 or more employees. Okay, so similar to the FMLA or the current unpaid Washington FML equivalent that this is replacing. However, if it's a voluntary plan, they gain their job protection much earlier and if they're with a smaller employer. So with a voluntary plan, job protection kicks in at 9 months tenure, 965 hours, and no minimum number of employees. So that's an important distinction to be aware of. When we think about another comparison here, state versus voluntary from the employer perspective, I tried to break it down. So the costs, right? The costs will be, if you go with the state plan, it's 0.4% of wages. You're paying 37% of that unless you're an employer with less than 50 employees in the state, not total, just in the state, in which case you have no contributions. And the benefits are being paid by the state, right? So if you go with the state plan, your maximum contribution is going to be 37% of 0.4% of gross wages for your Washington-based population. If you go with a voluntary plan, you get to keep any of the employee premium deductions, right? So you keep that money that goes into trust. You can use that to pay the benefits plus whatever you would have contributed. But you are paying the benefits. And here's the catch with this one. It's really going to be a challenge to estimate what that's going to cost you in benefits because, as I mentioned, it's not based on what your employees make today, right? It's based on what they made, all employers, over the last 4 quarters. So that's where this is going to be a little bit of a challenge, is trying to determine, if you're weighing these out, what's the cost to you on a voluntary plan. Determining the benefit cost is a little bit it's going to be guesswork there. And of course, if you hire a vendor to do that for you, you'll have to factor any administrative fees as well. Reporting, similar. Quarterly reports will go to the state, which includes their hours worked, premium taken, those kinds of things. You got to do that whether it's a state plan or a voluntary plan, because the state will always own the data. But if you do a voluntary plan, you have to also then report weekly wages or not weekly wages, but weekly benefits paid and the duration of any leave provided. From a decision perspective, the state will always own the decisions around eligibility and average weekly wage. They'll also know any benefits that have already been paid in the last 52 weeks, maybe by them or by a previous employer under a previous voluntary plan. You as the employer or your third-party administrator is then going to have to, your decision making is just reviewing the medical or the documentation and making a decision around how duration of benefit to be paid, right? And some of that's going to be in partner with the state. So if the state knows they've already taken 12 weeks of leave and they've told you that, then you know you're limited to 4, assuming the medical supports that, that duration. So that's a high-level overview of some voluntary plans. We want to take another quick survey to see how many of you may have already thought about private versus state plan and made any decisions regarding how you think you may handle that. Give you guys just a few more seconds. I've got 60% of you voted so far. All right. Keaton, go ahead and close that out at about 80%. So it looks like the majority of either don't know what you're going to do or you're going to go through the state. And I think that's what Jean and I have both been hearing pretty routinely out in our work with employers is there's still a lot of unknowns. And as a result, it's hard to make a decision, which means that in the meantime, maybe go with the state or at least be submitting premiums for the first of the year, and through the course of 2019, make some decisions from there.
And I
wanted to do one,
quick minute. 2 weeks ago, during one of the advisory committee meetings, they shared an update in terms of how many applications they had received to date. And they've only received 11 so far, but there was I think 5 in the last week, so they are expecting more. But 11 total applications so far. 9 of those applications for the voluntary plan were for both medical and family, and 2 were for medical only. They had reviewed and approved just 1 so far, and their turnaround time on that decision was 14 days, though they think that will improve as they get more comfortable and have more experience reviewing the application. So that's just some information from the state in terms of what they've seen so far in terms of the voluntary applications submitted.
Thanks, Jean. Yeah, that's helpful. I know the state's prepared to take those applications and they're waiting for more. So quick comparison to FMLA, because this comes up as well. And some of this we've already talked about, but it's just nice to have a visual graphic of how they compare. So the difference really as far as qualifying reasons for leave between the federal FMLA and Washington is that military caregiver component is not covered under the Washington law, but your other serious health condition and parental leave qualifying exigencies are. One of the big differences Jean mentioned is the qualifying family members, right? Federal is parent, spouse, child, and if that child is an adult child over the 18 or older, they have to be disabled and capable of self-care. Under Washington, you're going to add to that domestic partners, in-laws, grandchildren, grandparents, siblings, and children can be any age. So you will have situations where maybe an employee has used all of their FMLA leave or used all their Washington leave to say care for a sibling, they're still going to have 12 weeks of federal FMLA available to them because those are not going to run concurrently. You're also going to have situations that first year of the plan where employees went through all their FMLA in 2019, all 12 weeks. They've got a fresh bank of Washington PFML available to them on January 1st, 2020, even if it's for the same reason, right? That bank is fresh and new and clean, and they'll have it available to them. So you're going to have some, we talk about it being concurrent, but there's going to be a lot of scenarios where it's not, and employees are going to be able to stack some of this leave, which becomes important if that leave is job protected, right? FMLA is always job protected because they have to meet that 12 months, 12, 15, 50 employee threshold just to be eligible. As I mentioned under Washington, difference between benefits payable and job protection, right? So benefits payable are once they meet the 820 hours, any employer. So it could really be day one with you, potentially. But job protection, again, is going to be similar to FMLA with the 12 months, 12, 50, and 50 employees, unless it's that voluntary plan in which it's going to have more generous provisions. A couple other key differences. I went too far. There we go. Okay, sorry. I think I'm missing, am I missing a slide, or can I just not get to it?
Darius, I think, there you go.
Oh, there it is. I skipped it to start with. Thank you, Jean. You and I are having the same issue with the advancing slides here. Covered employers, 50 employees, obviously, for federal FMLA, whereas Washington applies to absolutely everybody. We did talk about the eligibility. Again, FMLA 12 months, 1250, whereas Washington is at 820 hours, plus potentially 340 hours for you specifically if you've got a voluntary plan. FMLA is the 12 weeks. It can be under any calculation method. You guys should all be familiar with that, at least if you have at least 50 employees. Some of you are under 50 and you don't currently have to deal with the FMLA. So this concept of job protected leave could be a new challenge for you. But it can be calculated multiple ways, rolling backward, measured forward, fixed year. The Washington will be, as we talked about, 12 weeks family, 12 weeks medical, max of 16, but it will always be in a measured forward 52-week period. So they will take, when that application for benefits is received, that sets the clock for a 52-week block of time. So that's going to be another challenge, is that FMLA and Washington are going to be running on different calendars when you think about when they replenish time. The good news is the state's the one that'll keep track of that, right? Because again, arbiter of the data. From a leave schedule perspective, FMLA can be taken continuously, intermittently, as many of you know, much to your dismay, down to the minute from an intermittent perspective. Washington has said the minimum duration is 8 consecutive hours. So we think the way that will be interpreted in the regulations is that it will allow for intermittent leave, but in full day increments. But there's still some work for them to do there to kind of figure out how to interpret the whole issue of consecutive hours when you have maybe part-time employees and how that will play out. So we're waiting for more on that. So I've already covered the next slide accidentally first, and now I will hand it to Jean to talk about some of those employer requirements. Oh no, this one's me too, sorry. Got myself mixed up here. Sorry, guys. So like FMLA, you do have to continue health insurance benefits, but only if you're already doing it under the FMLA. It doesn't have, Washington does not have its own requirements for continuing benefits. You do have to keep any records related to your premium collection for 6 years. There is a poster, a notice that will have to go up around the rights and responsibilities for Washington paid family leave. They will provide a poster. Also, you're going to have to notify employees of his or their rights with a written statement once they've taken 7 consecutive days of leave, or within 5 days of the notice, whichever is later. But I did ask, this question's come up, since premiums start 1/1/19, is there some kind of notice or posting requirement for the premium component that starts on 1/1/19? There is not, although I would say probably a best practice to let your employees know it's coming, but there's not an individualized requirement for that right now from a posting perspective. Employers cannot interfere with an employee's rights under the Washington paid family medical leave, cannot discharge or discriminate against any employees for opposing any of the, kind of factors of the law. If somebody files a complaint, again, so you've got to allow the employee to exercise their rights under this law. That does not make it job protected unless they've met those other requirements, right? But you cannot retaliate against employees who exercise their taking this benefit, which is going to be an interesting dynamic when how that's going to be interpreted For an employee who say is not eligible for the job protection component, but for a benefit, how does this get interpreted? Can they be subject to an attendance policy, or is that interfering with their rights to take leave? I don't know. It's going to be fascinating to see how that plays out. Okay, Jean's going to talk about some of the reporting requirements.
So first off, in terms of what employers will need to be reporting every calendar quarter, you can see here the list of information that they have said at a minimum will be required. They are still in the process of finalizing these requirements. And they're really enforcing this in a big way because obviously the eligibility is portable between jobs. And it will be important for employers to have a place where they can potentially go in and get information for their employees. So more to come on that. The state hasn't said how that's going to happen, but they are in the process of creating a portal that will be a repository for information such as this. Here we go. Okay. The report includes not just premiums, but wages as well during that calendar quarter. And again, as Dara said, they'll be submitted on the last day of the month following the end of that quarter. The portal that the ESD is in the process of developing has 4 different portals to it. One is an employer-facing portal. There's a customer service portal, there's an accounting portal, and then there's a portal for voluntary applications. The first 2 are completed, but they are going to release this all at once. So it's going to be released by the end of the year is what they've said. The voluntary portal is not yet completed. So for now, for employers who are interested in applying for the voluntary offer, there is a website link to use for that in the interim. So more to come on this area. This is an area where they've been working on, but you can imagine it's a pretty heavy lift. So they've got still some work to do here before it's customer ready. And I think that leads us to the next question. Here we go. So based on what you've all just heard, this will be an interesting question for you to respond to. And that is, what are your highest concerns, or if you have any, what is your highest concern about the Washington paid family medical leave? We've just chosen a few here. We might not have captured yours, but these were some of those that we hear often. Okay, we got a good 72 or 73% response, and you can see here the lead horse is the burden of administration and reporting requirements. Not a surprise, especially after the last section that we just covered. So thanks for your participation. And Darius, I think it's back to you.
Yep, I'm just going to briefly touch on what vendors are doing right now from a solution perspective. I will tell you it's a challenge, right? So one of the keys for any vendor on this is going to be access to employee data, right? And all the components, because we've got to know, are they eligible for a state plan? We'd have to know what their average weekly wage and benefit amount are. We'd have to know how much leave they'd already taken. And that's going to be regardless of whether as a vendor we're administering a private plan on your behalf or just administering, say, a wraparound or top-up disability plan or your paid parental leave or something to that effect. So the things that we're looking at as a vendor, and I know all of our peers are as well, is, okay, how would we administer a voluntary plan, a private plan? What would that look like? And again, access to data is going to be critical, but aside from that, how would we do that, and what would those plans look like? What about existing disability plans for that medical component? Do we need to offset? Do we need to provide plans that kind of wrap around or top off to a state plan that could supplement potentially? And again, still waiting on answers from the state on what that supplementation would look like. But knowing that at least an existing disability plan will likely have to change to the minimum offset for the state benefits. Paid leave plans, if you have a paid parental leave or a paid family leave that you're offering, how is that, similar to a disability plan, going to offset and accommodate for any benefit an employee may be receiving from the state? And then lastly, how does that integrate with any leave management services the vendor may have? So if they're doing FMLA administration, that concurrency, what about the job protection component, right? Because the state's going to tell you if they've been received a benefit, but the state's not going to tell you if they've got the 12 months or the 1250, or if they're working for you directly, if they have the 9 months and 965. That's up to you as the employer to track the job protection component. So if you have a leave management vendor, how are they going to integrate that data as well with what they're doing? So those are kind of all the components that as vendors we're looking at and finding solutions for, and waiting with bated breath for the state to come out with regulations to help us in some of those areas, but definitely helping to find solutions for employers. And then Jean, what do employers need to be doing right now? That's what vendors are doing. What do the employers need to do?
So real quickly, we'll recap the next steps that we think you're probably already working on, but just reminders. Determine whether or not you are going to go to the state or you'd like to apply for a voluntary plan. Those applications, the state is encouraging people to get those in soon. They've suggested that by the end of November would be safe. Much after that, they can't guarantee they'll get the application process timely enough to have your decision by January 1. A lot of that, I'm sure, will depend on how many applications they end up getting. And then if you are going towards a voluntary plan, to set up that trust that you'll be collecting your premiums in or depositing your premiums in. And then it's not too soon to have conversations with your payroll vendor to determine what the process is going to look like to collect and remit premiums. And then there's some other conversations to have within your organization to really start to think about what impact might this have to your company. We would estimate that you'll see an increase in the incidence of leaves. Maybe not necessarily in the medical side, especially if you have already a managed short-term disability plan. But for instance, if you don't, then you might see a significant increase in the paid medical leave. And for family leave, we feel like this is going to be an impact to most organizations for a couple reasons. Employees will now be paying for this benefit that they know they're entitled to. The state will be conducting a very robust communication strategy. They've already started at the employer level to communicate that this benefit is available and what are the uses for it. And they're really proud about this benefit and really want employees to know that it's there and available for their use beginning January 1 of 2020. And then if you consider for family leaves right now, Washington does not have any paid family leaves in place. So for those employees who in the past might have not been able to go care for a family member with a serious health condition, because of the finances around it and they couldn't afford to take the time off to do that, it will be a different decision for them now because they do get at least a portion of their pay in the same scenario. And keep in mind, the eligible family members is much larger than what would have been available, what is available under the Family Medical Leave Act. So there's definitely some education needed all the way around, both for employees, because at a minimum, they'll have two different processes to apply for leave, one through the state and one through your own company for your own FML or other company leave policies that you might have, as well as training for HR and benefits, as you can see from the examples that Dara's had, the comparison between the differences just between the state and the FML. There's a lot of intricacies that will be kind of a give and take situation depending upon what the leave is for. Employees that exhaust paid family might not necessarily be exhausting family medical, or they might be eligible for paid family medical but not for FML. So there's a lot of scenarios just to talk through or have training on so that you'll be ready for that those changes when they come January 1. There's also the whole conversation about ADA, and exhausting PFML doesn't necessarily mean that they're not eligible for additional unpaid leave through ADA. So same kinds of situations that you find yourself currently with FML, but now extended to another leave benefit through the Washington plan. And then finally, I won't expand upon that first one, I think Darius did an awesome job of really talking about the different scenarios in terms of other plans and policies that you have in place. The last one might be one that you've considered or you're already doing, and that is to consider outsourcing and whether or not that makes sense for your organization. So that would mean taking your current leave administration and maybe looking at an outsourced solution through a TPA or a insurance company, or bringing it in-house with a technology solution. So as a way to help manage the chaos of all the different plans, the intricacies of them, and also, always important, mitigate your risk. For more information, we thought we'd provide you with some places to go for that. I would highly recommend the first one. That's the website for the Washington Paid Family Leave within the ESD department. And just last night, they have created an employer toolkit. So you can go on there and get a sample of that. It includes a handbook sample for your employees. It includes pay stub inserts, a sample newsletter wording for that you want to send your employees, a calculator to estimate your premiums. Several good tools are available in that toolkit, so check that out.
Yep, and Jean, I'm just going to add really quick, I think there's also a link there for what they call the Voluntary Plan Guide. I saw several questions come through regarding, how do I get an application for a voluntary plan? What's the process? They've published a Voluntary Plan Guide, and I think there's a link to it through that toolkit as well.
Great point. Yes, that's correct. Thanks, Darius. And then also there is going to be that required notice that Darius mentioned that you'll have to post. That is not yet available, but they will have that before January 1. Oh, don't forget, please take a couple minutes if you could please to answer our brief survey. And if you still have questions or would like further information, I'll leave you with both my email and Darius's. And thank you for participating today. We appreciate it and hope that it was a productive hour for everybody. Have a good rest of your day.